The involvement of lawyers and judges in deciding corruption cases usually puts them at the center of public criticism. That default perception from the public seems to be the fundamental difference in the relationship between the judicial officers in question and informed society. But analysts say it's one of the hazards of the job. Are those judicial officers doing enough to serve the cause of justice, which is the barest minimum expectation from its citizens? There is a view that recent experiences within post-election education in Nigeria have done pretty little to disabuse the minds of many Nigerians on this matter. Well, Dr. Sam Amadi is the director of the Abuja School of Social and Political Thought. He joins us now. Very good to have you on the show, as always, Dr. Amadi.
Thank you, and good afternoon.
Well, historically speaking, is it fair to say that lawyers and judges might have played some unfortunate roles in the aiding and abetting of corruption within the country, especially within such cases that come across their desk?
I think it would be fair to say so, not just in the country, across the world. I mean, we know, not just for corruption, for many of the evils that we look back today and lament, whether it's slavery, whether it's racism, the law is at the heart of social change and social stagnation. And so the principal actors who are central to the dialectics of how law shapes society are judges and advocates, what we can call now lawyers. So we've seen through history globally that looking back, there are many moments that the law failed woefully, or the law kind of accelerated, deepened a very evil or violative social order. And to Nigeria, yes, we've had moments that we could look back and say, maybe the law should have done better. Maybe lawyers should have done better. Maybe judges have done better. What has made it perhaps more so is the fact that there are many anecdotes and some verified reports. If you look at NJC's petitions, some of them, they don't get to convict and dismiss the judicial officer. But notable allegations that are credible, even not legally or judicially proven, about corruption, about how judges themselves have aided persons who have abused or seem to have abused processes. I mean, notable one, the last election, we saw even both the Commonwealth, in spite of their usual non-interference and double speak, were very clear as to the Lawal case at the Supreme Court. I mean, that's now well known. The Uzodinma's case at the Supreme Court could be one instance, whether for pecuniary or no pecuniary reason, where the general perception, not just of Nigerians, but of course internationals, diplomats, cross-section of human beings, of persons with different interests and perceptions, that the law failed significantly. So we can, and then we can see cases where exactly where there was actual corruption. I remember as a young lawyer with Chief Gane Fahimi, when the Supreme Court judges themselves then sued Concord newspaper journalists for a report about how they were cozying up to government, receiving vehicle from them provided by Julius Berger on behalf of government, and so on and so forth. The case, the judges themselves had to sue Concord, and Gane Fahimi had to represent them. There are also cases where two different judgments have been provided at different times to different people. So there are notable cases, both proven and anecdotal, where we can say that judges and lawyers, didn't play to the professional pretense or professional reality of the rules that guide the profession. Again, speaking for me, I think I'm not more worried by lawyers and less by judges. I mean, for one reason, judges are very, very determinative. They make the right decision. But the lawyers now who corrupt public discourse, I mean, it's now some established cases of lawyers being procured to come on television or use another platform to make statements that, and I speak from experience. Someone has called me and said, look, can you get us a lawyer who can speak for this person for fee? So now this is why it's dangerous. Sapara Williams, the first lawyer in Nigeria on record, says the lawyer lives for the direction of a society. The legal profession has so much privilege and, power. I mean, there are many professions, but the legal profession is so significant because law is the life wire of society that they have extra responsibility. A lawyer can be controversial, and one of the famous rules, judges said, God forbid that a lawyer will know all the law. A lawyer can make mistake with the law. A lawyer can even take cases and ought to take cases of anybody who comes to him in the line of his practice, even if such a person is controversial. I mean, Chief Ganefa with me shows the direction when the trial under the military, when an NBA boycotted the tribunals because of, they were against military justice, quote unquote. Chief Ganefa defied the NBA, went to court to defend because he felt that he supported the anti-corruption war and he could defend anybody in the military tribunal. So that lawyers can be controversial. But when a lawyer deliberately, intentionally is procured to be making statements that rather destroy the basis of social transformation, that encourage corruption, then that's worrisome.
So sorry to interrupt you, but for the sake of time, I'm just wondering,
Go ahead.
How do we stop this manipulation, of our legal system by powerful litigants and senior lawyers, especially when in most cases, even our security officials are compromised, the legislative is also compromised, the ruling class is compromised. How then do we stop this manipulation?
I think there are three approaches. I mean, the one of judicial officers, I think we need to remove the Chief Justice of the Federation from NJC. I mean, the last Justice of the Supreme Court was retiring, talked about the fact that it shouldn't be only manned by judicial officers, senior lawyers, retired justices. In fact, more cases should be headed by a retired, reputable justice of the Supreme Court, so that they are not going to be there to be going through cases against themselves or against their colleagues who probably they share the same tendency or they have the same stories to tell. So I think we need to revamp the disciplinary procedure for erring judges to remove a sense of conflict of interest and collaboration. Let it be more open, let the procedure be well written out so that we'll be able to take people and successfully interdict and indict and remove bad judges. Now, on the part of legal practitioners, I think there are two categories. Those who work in government, Nigerians have not estimated the danger that legal advice does to procurement, to corruption in public service. I've been a chief executive. Oftentimes, they use legal advice to cover up for crime. So if a chief executive wants to do something wrong, do a procurement that is illegal, they'll go to ask for legal opinion of the legal advisor. Legal advisor will concoct nonsense and say, in my view, you are permitted by law, you can do this. So that provides a cover and an excuse for the corrupt chief executive. Even the office of the Attorney General, they are notorious. As NEC chairman, I refuse to take those advisory. And I tell my colleagues, look, I know the U.S. Supreme Court in the case of Chevron, INC, says the regulator is the first interpreter of his act. And I said I won't accept very bankrupt, procured advisory for the Attorney General's office to direct us to do what is wrong. So we need to make a law to put skin in the game. Any lawyer who is a legal advisor whose advice led to misprocurement, to all this corruption that we are trying, governors, chief executives, the lawyers who give advisory should be prosecuted. So there should be a law that says, I proposed it to NBA several times, that says if you're a lawyer in public service and advising government institutions and you deliberately misadvise them and it costs the nation, for example, some of the cases we are not being indemnified in damages because lawyers advised wrongly, they should be prosecuted. And finally, again, we need to also platforms, televisions, and all that should let lawyers who appear on these platforms know that they have a public service. When you're coming here, this is not to make a case for a client. This is to help the public understand the issues around a naughty legal issue, so that we begin to require a high level of objectivity. In fact, let me say this, as a lawyer and as a law teacher myself, I think there's a high level of lack of professionalism and even poor education among many lawyers. I mean, the senior ones, people come and just talk section A, section B. They don't really get to the policy side of the law. So somebody can tell you whatever a judge decides to obey. They won't tell you that some of these decisions are unjudicial. No judge should forever, any reason, say that the police, EFCC, constitutional institutions should not query you investigate, invite you, arrest you. It's unconstitutional. A court can say, these are the conditions for this to happen, but they cannot give you an immunity at large from due process of law. So when lawyers come to speak on public domain, they should speak as public advocates. They shouldn't be speaking as persons who are paid to defend a client, because the reason why they're brought in there is not to make a case for their client, but also to help the public understand the policy issues around. So I think if you have these three measures, a much more reliable NJC procedure where not the Chief Justice themselves are sitting over to the time, but credible retired judges and other persons sit to look at these disputes. Secondly, there should be a law to debar and punish lawyers who flagrantly advise chief executives of government institutions to undertake tasks that they ought to know are illegal. And if there's evidence that they received pay because of that, they got benefit for that, they should be damned seriously, because there's a high level. I've been at the executive, legislative levels, and I've seen how lawyers, including those at the Office of the Attorney General, they give very corrupt, procured advisory that provide cover for very corrupt and criminal actions of state, and then the government loses resources or the government loses opportunity. Those lawyers should, NBA should lead in this new law so that they are punished for, violating public trust. The legal profession is almost like a public trust, even though, partisans use it to make money, which is fair, but they have a public responsibility, and the state should punish them when they advise actions that turn out to be flagrant, corrupt, and, self-serving.
Very, very well said, Dr. Amadi. And in light of these three solutions that you have obviously thought quite heavily about, what does it portend for our democracy if none of these solutions are at least partially implemented going forward?
If you look at the history of democracy across the world, you look at the major actors, lawyers, legal statesmen, judicial statesmen who are lawyers, have played key role in directing them towards freedom and democracy. You can't talk about democratic struggle. Even Mandela himself was a lawyer. Even Gaddafi, if you look at Cuba, the revolution, was a lawyer. So lawyers, if we fail, and we are seeing general deterioration, both in the learning level of legal practitioners. Sometimes you see lawyers talk on television, they keep quoting, quote. They basically are not helping the public grasp the crisis and provide insight for how to solve it. We need to, if we don't improve the quality of learning of lawyers, if we don't improve the quality, even with due respect, when I read judgments from our courts, I have to say that clear, and I compare judgments from the US court or the UK court, I see the quality of reasoning. It's not enough to say A is A, B is C. You provide reasoning that address a conception of the democracy and the state. That level of learning is missing. Maybe because the previous judges went to Oxford, some went to London, some had good grounding in what they call classics, then in social sciences. Maybe it's time now to think around law in Nigeria as a postgraduate degree, to increase the analytical and substantive grounding of lawyers in logic, in social science, in understanding what these sections actually mean in terms of the evolution of democracy. So I think if we don't improve the quality of learning, of knowledge in the legal practice, and the quality of accountability, holding lawyers to account for what they say, for what they do. In fact, there's several stories of corruption. Look at allegations about appointment of judges and maybe cronies, daughters, wives. There should be a sense in which we protect that gateway into the judicial profession or judicial side of legal profession. It's been polluted. There's just pollution everywhere. And so if they continue, it's going to ruin this commonwealth, because the work that lawyers do cannot be done by anyone else. They don't be the ones who are crafting laws. Look at the quality of laws that come out lately. They don't address the problem, because that's a missing tool, which is social science research that should guide legal reform. Is absent. Look at the integrity that our even election cases, allegations. So we have to really improve the quality of learning of the legal profession, improve the accountability to discipline. And institutions like the retired Chief Justice said, we should make sure that judges are not the ones oversighting themselves. We should transform the NJC and make sure that judges who are errant get punished on time.
Very well said. Dr. Sam Amadi, Director, Abuja School of Social and Political Thought. Thank you so much for joining us on Newsday.